Hello, everyone. Good afternoon, and welcome to Romola D Reports. I'm here this afternoon with a very illustrious guest. Edward Ellis is an equity lawyer whose special expertise is management of the equity monarchy trusts, which govern Parliament session powers for the United Kingdom Parliament. Now, he tells me that they fell into disuse for many years when the politicians developed, for 45 years, when the politicians developed the European Constitution, which vested dictator powers in the state. The European leaders needed election frauds to get referenda acceptance of the European Constitution. Equity lawyer Mr. Ellis got the election fraud proof and revived use of the equity monarchy trusts. It started a corruption remedy process that has continued for 15 years. Presidents Obama and Trump both assisted with the remedy process. The issue now is remedy publicity. It is how the population will discover the scale of corruption and what is being done to remedy it. So I guess that's what this afternoon's podcast is all about. So welcome, Mr. Ellis. Thanks so much for joining me this afternoon.
A pleasure.
And, as you know, we've been having a little bit of a conversation prior to actually recording. And I obviously have a whole list of questions to ask you, starting with the very basics. What exactly is equity law? What exactly is this corruption process you're talking about? Although your introduction certainly points us in the right direction of these monarchy trusts. So if you wanted to talk a little bit more about that and give us a bit of an understanding, a ground understanding as to what this is all about, that would be super helpful, I think.
Well, the common law is designed to deliver equity, fairness as between people. The equity monarchy trusts are a common law creation. We had dictator kings. We had a civil war. We then had a dictator parliament, which was worse than a dictator king. And so they brought back Charles II. He had the intelligence to govern. He knew where the boundaries would be. So he governed successfully for 25 years. He had no legitimate children, and so his heir was James II. He was technically clever and judgmentally impoverished. He thought he could tax a Protestant nation to build a Roman Catholic church or cathedral in Whitehall. So people like me decided to get rid of him. They did not want a civil war. They just wanted rid of him. So they had quite a complex process that persuaded him to leave the jurisdiction. So they then accepted his daughter and son-in-law, William and Mary, as monarchs on the condition that they accepted the equity monarchy trusts. So those are three corruption control jurisdictions, one for the citizen, one for the crown, and one for the Lord Bishops. The citizen has investigation jurisdiction. The crown has prosecution jurisdiction. The Lord Bishops have adjudication jurisdiction. There are 24 of them, so up to 12 can sit as trial jurors, and up to a different 12 can sit as appeal jurors. Nothing happens until the citizen gets corruption proof. But when the citizen does get corruption proof, the Crown and the Lord Bishops then have to do something. And so we have Parliament periods. At the moment, it's 5 years. And then we have, within those Parliament periods, between the general elections, we have Parliament sessions. And when the Queen sits and reads out a speech about what will be done during the Parliament, there has been an entire process to decide whether or not it is valid to have that session of Parliament. If there has been corruption proof, it's valid to have it on corruption remedy terms. If the corruption is bad enough, the ultimate sanction is a Parliament session refusal and forced general election with mass publicity for the corruption proof and the remedy denial fraud proof. So the whole idea of not using the Equity Monarchy Trust for 45 years was so that everyone would forget how to manage the Equity Monarchy Trusts and eventually would forget they existed at all. So any education about the Equity Monarchy Trust was removed from the system. And the people who didn't need the universities to educate them about the Equity Monarchy Trusts were the Gnostic Christians who invented them. So there were families in the United Kingdom where the knowledge and expertise was passed down the generations. And the bright children in the families were told that they had citizen responsibilities and how they should manage them. I was told in my teens that I couldn't criticize Charles, Prince of Wales, for the way he managed his responsibility unless Edward, citizen of England, had managed his responsibilities. Criticism of the prince was conditional upon me having done something. So that was the same for everyone else. And well, I suppose there were many families that did not have the knowledge and expertise. It so happened I came from an area where a lot of people did. So I was surrounded by the understanding that we would have to do something.
That's really interesting. So you're saying the awareness, the consciousness of equity law and its reality and truth, and its continuing reality, it sounds like, is something that was carried down through the generations.
Well, yes, much longer than that. Originally Christianity was Gnostic Christianity.
Right. Prior to Catholicism, right? Prior to the popes and everything.
Well, yes. Gnostic Christianity was all about discovering truth and reasoning justice and a direct relationship between the individual and God.
Gnosis, direct knowledge, yes.
Right. So originally, the Roman emperors considered themselves God, and therefore anyone who recognized God independently of the emperor was a heretic. So there was a lot of abuse for a long time. And then about 250, the mother of a man who later became an emperor converted to Christianity. And from that time, it was no longer politically unsafe to be a Gnostic Christian. So Gnostic Christianity had gone from Israel along the North African coast to Spain, and then to Ireland and Roman Britain. It didn't come through France. And when it arrived in Roman Britain, there were some very pragmatic people who decided that there was no point waiting for heaven. You might as well try and build heaven on earth. So they took the concept of the Roman citizen and decided that instead of being a petty dictator, the citizen should be responsible for the control of power rather than the possession and abuse of it. So they developed the common law. Now, they made the common law God neutral very deliberately, because the vast majority of the population were pagan, and they didn't want arguments about gods to get in the way of progress. So they developed the common law, and the pagans accepted it. As the Gnostic Christians prospered, they took the common law with them to deal with trade disputes. And a lot of the pagans came to be interested in Christianity through the common law, rather than because of...
Rather than the evangelisms associated with Christianity itself.
Yes.
That's interesting.
And then, of course, what they also decided was that they had to eliminate the imbalances of power between parties. It's the concept of party equality. And the biggest imbalance of power is between people who cannot read and people who can write.
Right.
So, and they also realized that for people who couldn't write, there were a lot of people who were intelligent, and their intelligence had to be expressed in other ways if they couldn't write. And so there was always going to be, the system was always going to be vulnerable if you had intelligent, driven personalities who felt they were left out. So
absolutely,
it was an oral tradition, and all decisions had to be reasoned. They had the equity decision discipline, and that required you to discover what was true, reason what was just, work out all the possibilities, eliminate the worst possibilities, and you discover right by eliminating what is wrong. Very positive way to go about it.
Absolutely.
So when Constantine became emperor, he realized the monotheistic religions were growing, and they were about 9% of the population at the time. So he took the risk of making Christianity the official religion. Now, it was a big risk, but he was a military dictator, and he was obviously a clever man. He got it right. What he then did was there were two emperors at the time. There was one for the eastern part of the empire and the other for the western part. So he got the other emperor to agree protection for the monotheistic religions. Then he sent someone to kill the other emperor and admitted it was him that had him killed. And so he was asked, why did he kill the other emperor? He said, well, he was going to attack the monotheistic religions, which was a lie, but it put Constantine in the position where he could present as being the protector of Christianity. And so they had an assembly, and it decided Roman Catholicism, which was a moral dictatorship where the individual was dependent upon the priest for access to God. So
that's a brilliant explanation of how it all came about, considering that it sounds like a very strategic military decision on the part of Constantine.
You have to admire the intelligence and competence with which he did it. Now, in some ways, it might have been better for peace, at least until most of the population was Christianized. It may have been the only way that the emperor could have kept the empire together.
But that was his point of view. I mean, I'm sure the people didn't want to be roused from their pagan worship of whatever they were doing, their peaceful worship of their own gods.
Well, it wasn't that he forced them to abandon paganism. He just rode the wave of change. It was very clever, and he got it right. If he got it wrong, he'd have just been one more failure in history. But he got it so right that the moral dictatorship continued for generations. Now, my father told me that it was the Gnostic Christians who developed the common law, and what they had done was popularize objective reasoning. So when Roman Catholicism came along, effectively the age of reason was then crippled for about 1,000 years. And because it was a dictatorship, anyone who questioned the way things were was threatening the dictatorship. Dictatorships cannot cope with instability.
Or intelligence, or questioning.
Well, yes.
Or independence.
But this is why the Gnostic Christians who developed the common law got it right. It was designed to cope with change, that the duty was to discover what is true and what is just. Well, that requires you to take into account all changes that have happened. So effectively, you had two different systems. The Roman Catholic Church had a legal system that was designed to ensure the bishop never had an argument with the baron, because he had the armies. So you had things like trial by battle and trial by ordeal. Whereas the Gnostic Christians, it was all truth and justice. So what much of our European history has been the conflict between the two systems. And
except not many people had recourse to the other system, right? The common law system. It's never in.
You're quite right. But there must have been times when they did. You see, there weren't just Gnostic Christians, there were Gnostic Jews. There were probably Gnostic Roman Catholics. They might have been safe to be a Gnostic Roman Catholic until the Roman Catholic Church got too powerful. In the 9th century, the Vikings invaded England, and the Gnostic Christians had a significant part of central England. And within a generation or so, they would have expanded. And once their territory reached the Wash, the River Dee, the River Severn, and the Thames, the whole of the British Isles would have been irrevocably Gnostic Christian. So in the 9th century, there was a Viking invasion. The Saxons royalty had converted to Roman Catholicism for diplomatic reasons. You could not invade a Roman Catholic state without permission from the Pope. So in England, you had Gnostic Christian practices, you had a royal family that converted to Roman Catholicism so that nobody could invade without permission from the Pope. It was one of the diplomatic blocks. And So the Saxons went to the cardinal for military support to defend a Roman Catholic state. The fact it had Gnostic Christian laws was neither here nor there.
Mm-hmm.
So the cardinal insisted that the military support be given on condition the Gnostic Christians were excluded. So the Vikings made their way from northern England, found they had no resistance, and so the Gnostic Christians were forced to abandon their land and trade land for carts. And so they were landless, harassed, and tempted with safe haven behind the Saxon lines on condition they accepted Roman Catholicism. Well, there must have been quite a few who did, but the majority did not. And so there was this tribe that held together when it was landless, harassed, and tempted. And both the Vikings and the Saxons and the cardinal, they all realized that the leadership model of the Gnostic Christians was more powerful than their own. They might have been able to hold together landless and harassed, but they definitely couldn't have kept their following where there was temptation. So England is not a large country. So this group made their way along the Saxon boundary, and both the Vikings and the Saxons realized that if this leadership model sided with the other side, they were doomed. The force, that power would break what they got. So both the Saxons and the Vikings were then suing for peace with the Gnostic Christians. So they split into three. Part of their tribe went behind the Viking lines, part behind the Saxon lines, and a third group set up a trading camp in the Northern Rhine. And that's how the Dutch got jury trials. And they sent an emissary who established a base camp in southern Switzerland and went and saw the Pope. So he turns up to see the Pope and says to the Pope, well, what do you think you're doing? And of course, the Pope blames the cardinals for being too ambitious. So,
oh, really? He sort of disassociates himself from being a part of it.
Well, dictators do dissociate themselves from failure. And so the deal,
interesting point.
The deal was done that the Gnostic Christians would provide the Swiss Guard so that anybody who went to the Pope to get a blessing for war, the first people to know about it would be the Gnostic Christians. Effectively, they told the Pope, well, either we get some arrangements that satisfy us, or we will side with the Vikings, and it won't be a few raids to steal some trinkets. It will be a war to systematically destroy your power base. Under that pressure, the Pope gave in.
I'm very curious, though. I mean, if the Vikings had the firepower and the Roman Empire also had that military power, and you're saying the Gnostic Christians basically had the power of truth, justice, and leadership, how exactly did they persuade these people?
Well, what it amounted to was they had demonstrated how robust their system was. And right. So effectively, dictators concentrate power and are then very insecure. they know something can go wrong. One of the emperors described the position of being Roman emperor as being riding a wolf, trying to control it by tugging at its ears. Now,
that's a good one.
right. Yes, I know. Made me laugh when I first heard it, and here it is all these years later. He must have been quite a witty emperor.
Yeah.
and so when somebody presents as being strong and able to mobilize other people, dictators start to worry about it.
Yes, but these days we're living in very different times, aren't we? We don't.
Well, no, the same is happening now. The same is happening now. What happened to revive use of the equity monarchy trusts was the European political leaders wanted referenda acceptance of the dictator powers in the European Constitution. So what they needed election frauds to get referenda acceptance. They needed dictator power concealment frauds. They planned, for example, to have electronic signature dictator powers so that an official could telephone you, tell you to do this now or we will cut you off from your money. And if voters had known they planned electronic signature dictator powers, they would have it would have guaranteed rejection votes. Well, it so happens that British citizens had developed the capacity for advanced electronic signatures. It needed writing behavior analysis. It needed an internet delivery mechanism. And then it needed priming demand. Enough demand so that a service could be provided all the time. And so one set of citizens developed the analysis. A very talented banking expert developed the delivery mechanism, and the security services were so interested in it that they intercepted all the testing. The testing was done at 2 terminals in East London. They were 5 kilometres apart. The Docklands exchange was in the middle. And so he received a telephone call saying they notice he's using the system all the time. There were going to be some works and they let him know when they were finished. So the works were done and he was then told the service would be resumed. And he noticed that the system was a bit slow. It was about half a second slow. So he did another ping and found that the distance had grown from 5 kilometres to 7 kilometres without either of the terminals moving an inch. So it meant that the Secret Service had, within a 1 kilometre radius of the Docklands exchange, they were intercepting every single transmission.
Of course. Wow.
And
amazing. But expected.
It gets even more interesting because there were 2 ways in which the Secret Service agents could have done the monitoring. It was intercept, resend, run, or intercept, run, resend. Now, the difference between the 2 would be no noticeable delay on the intercept resend, but a noticeable delay of about half a second on intercept run resend. So it was the delay that caused him to do the ping and discover the extra distance, and only the Secret Service could have done that. Now, the issue then is, did the Secret Service use the delay routine rather than the no delay routine carelessly or deliberately? I think that they did it deliberately, because Prime Minister Mr. Blair had lost control of part of this Secret Service. He had sent men into danger in Afghanistan, and when something went wrong, wanted to have nothing to do with it. So some of the Secret Service officials did a rescue plan for the men and forced the Prime Minister to accept responsibility for it. So there came a time when he was Prime Minister with all the powers, and the Secret Service were running the show.
Very interesting. I see that sort of establishes what you were trying to say earlier.
Oh yes. So what I think happened was that the Secret Service officers realized that there was a major development here that was going to have enormous potential, and they had more respect for the British citizens who developed the technology than they did for Prime Minister Mr. Blair. You see, they do not recruit idiots. I know people make jokes about the CIA
all the time. Oh, right. I'm a part of it.
But the British.
But you're trying to say that there is a whole bunch of really smart guys in there, and girls, ladies as well.
Yes, there are, and anyone who underestimates them, there are bound to be mistakes. I mean, the British Secret Service has been penetrated by spies. There's no in our history, but you would not expect the mistake of carelessly giving the warning to the people who are being eavesdropped. And where we need to go with this is, we have got so much proof now that the corruption was so bad that honourable members of Parliament believe we need a forced general election in order to shock the system into the scale of change that is needed.
Now, what would that mean exactly? What exactly do you mean by a forced general election? In a sense, kind of stop what government is doing currently and then say time for a new election? How do you do that?
Well, this is it. The equity monarchy trusts govern Parliament session powers. We have general elections in order to shake up the system so that you don't get a small clique in power for too long. But you then need a control as between the Crown and the Prime Minister to keep the government straight. Well, we lost that control for 45 years, and the system got horribly corrupt. And so what has happened is we had to get rid of Mr. Blair. He had made the extradition agreement to get rid of a British citizen whose lawful business was going to expose advanced electronic signatures. It was going to draw attention to dictator powers to control electronic signatures. So
That's what I was going to ask you about, that whole thing about electronic signatures. There's a huge story behind that, right?
yes,
What is the significance of an electronic signature to start with, you know?
well, it's the advanced electronic signature is something the individual controls. It needs a discrete pattern, facial recognition, fingerprints, DNA. They're all express patterns. Once a computer has got your fingerprint, it can pretend to have it any time. So the writing an analysis technology enables the individual to write anything. And if they don't use ink, they use a plastic pen, there is no trail. And only that, if it's converted, then encrypted, it's only the individual who knows what they've written. So in order to replicate it, when you write, the reason your writing is recognizable is the writing process is the same and your hand hasn't changed. Your writing is governed by the ratio of the bones in your hand and the efficiency of your neural system. And your brain sends out pulses that tell you think you want to write something, it just comes out. You don't tell your hand precisely how to move. And because the process is the same, the actual signature or writing product is recognizably similar. Now, analysis of writing was done, and one enrolled on the system by giving samples. So you could write anything. It didn't have to be your signature. You could write the cat sat on the mat. You could write God save the Queen.
Mm-hmm.
You could write Arsenal is the best football club. Anything
Mm-hmm.
you like, so long as you didn't tell anybody else. First of all, they wouldn't know what you'd written. And then they wouldn't know how you wrote, because your writing is dictated by your physique and your urology.
Right,
So
but you ask a military neuroscientist today, and he'll be scanning your brain and, measuring the impulses through the nanotech in your fingers and
yes,
coming up with the
look,
right answer.
Let's be quite clear. What the in step with dictator powers, the dictators are interested in state, not process. They want fixed state, so they can do what they like and you can't do anything.
Right.
So there is
Absolute control, yeah, of the
there
citizen.
right. So the difference between the technologies that they use is they can monitor how you walk along the street or whatever. They are all things that can be observed. The citizen can think for himself what his signature is going to be, and then how are you going to get it out of him? You see, if he doesn't tell anybody,
Mm-hmm.
then you're not going to be able to impersonate him because you haven't a clue what he's written or how he writes it. Even if they were clever enough to analyze the flight path of the pen and decide how he wrote, they still don't know what he's written. So the level of security is phenomenal. And what advanced electronic signatures was going to open up was enormous markets for sophisticated services at value pricing. And what the Prime Minister, Mr. Blair, the choice when the technology was developed was whether to keep the dictator powers and suppress the technology, or abandon the dictator powers and make the best of the technology. Because you were never going to have the confidence that for the value price services if they were controlled by a dictator. So effectively, the European dictators decided to suppress the technology, and there were a number of things that happened, but of course the key thing was the extradition fraud against the British citizen, because when they tried the extradition fraud, absolutely everything that could go wrong for the Europe leaders did go wrong.
What is this extradition fraud, if I may ask?
What they did, the man who got the priming demand for the technology, they planned an investigation fraud by the Dutch authorities to seize him, extradite him from the United Kingdom, and imprison him. And so the first extradition fraud, Prime Minister Mr. Blair wanted to pretend nothing was happening. There was no extradition agreement with the Netherlands, and Dutch police with firearms were allowed onto British soil to supervise British customs into the kidnapping of a British citizen, pretending it was an investigation and due process of law. What went wrong for them was that the British citizen had what's called incredible target status. A policeman had been driven out of the police force because he was a drug dealer. He carried on drug dealing and had police officers as partners. He was a dangerous man to know. And so eventually he was put in prison and had to buy his way out. When he got out, he had to recapitalize himself. So he targeted small independents who couldn't defend themselves. This particular man had about £60,000 worth of cars on other people's forecourts. He used to buy cars, do them up, and get someone to sell them for him. So he had the logbooks and he had no debt. So the drug dealer tried to get the car logbooks off, the registration books, because they were cashable. And so he starts off by trying to get him to invest in this business deal that needs
to get his hands on them.
Right, yes. And so the man knew he was dangerous, so he didn't want anything to do with it. He played for time. He said, I've never done anything like this before. I need to sleep on it. All of this. Well, eventually the drug dealer, and I say eventually, it wasn't very long afterwards. It was all over a relatively short period. The drug dealer had the man kidnapped. And the kidnapping went wrong. So under that pressure, the victim went to Kent Police for protection. The police split into 3 groups. The honest officers tried to persuade him to infiltrate the gang, the Criminal Intelligence Unit. There were about 11 meetings where they tried to build his confidence to cooperate. Some ambitious officers tried to frame him so they could blackmail him into infiltrating the gang. And the corrupt officers tried to frame him to discredit him. The framing frauds failed. So by the end of the process, everyone knew he'd have nothing to do with drugs for profit when threatened with violence or under police supervision. That got for him incredible target status. So corrupt police officers and customs officers used his address as a decoy address on carrier movement records for more than 70 shipments of drugs.
This is shocking. I
Right.
wonder if this is the kind of thing they do to other people. Wow.
Well, so what then happens is they had a pallet in transit. When they received the assistance request, is how it's put, and arrest the incredible target, pervert the course of justice, destroy the business records so they could pretend he had no business, steal a vehicle from the alleged crime scene so they could pretend a fax and a phone call for parts for the vehicle were code for trafficking drugs. So the customs officers had no previous experience of an extradition fraud. They just couldn't believe the instructions. They thought that the victim had discovered someone was using his address as a decoy address, had reported it, and he was assisting with a decoy address investigation. So they got the BBC to broadcast big drugs bust, international cooperation, took control of the investigation in order to sabotage it. So the British citizen ended up in a British jail, and the investigation record was compelling innocence proof for him and compelling guilt proof against the corrupt officers. Now, when I say corrupt officers, let's be clear about this. There were junior officers who, in the course of this process, started off thinking they were dealing with a drug dealer, and then they realized that the drug dealers were the top customs officers, top police officers, and top judges. The process had discovered that top police, top customs, and top judges had a drug import business using the Kent ports. Now, wow. Imagine what impact that had on young people who'd started their careers and then realized that, in fact, organized crime controlled those justice agencies. So Prime Minister Mr. Blair had a choice. It was to abandon the extradition fraud and recover control of the state and law courts from organized crime, or to do a deal to carry on. So can you guess what he did?
That's really, really interesting. Well, for his public profile and so forth, he would have to actually reject that, right? Reject the extradition fraud.
Well, what he did was a deal to carry on. And
oh, really? Oh dear.
Yes. So
with who? With who did he do this deal?
With the protection fraud network is
okay, the entire syndicate, the crime syndicate.
Yes. So wow. So he did the deal to carry on with the extradition fraud and had to continue providing protection frauds for organized crime that previously had been given, provided by the judges. The difference was he could not say no. The judges could. So the judges were corrupt. but had kept a lid on the level of the corruption. Under Prime Minister Mr. Blair, there was an explosion of corruption. The organised crime managers took more risks lower down the pecking order and just demanded it be put right. So for me,
that's terrific to hear that those guys really stood up for what is right and they demanded that, it be addressed.
No, you've got it wrong. The organised crime managers did what they liked. There was no control. They just demanded that Blair provide the protection frauds, where the judge.
But are you saying the younger officers were therefore powerless in this scenario?
No. The younger organised crime managers were ambitious.
The younger organised managers
couldn't wait to make the big money, so they took more risks.
Okay, I get it now.
Their superiors had to go to 10 Downing Street for more and more protection frauds. So when Prime Minister Mr. Blair...
This is a nightmare.
When Prime Minister Mr. Blair said, stop that investigation, stop the other investigation, each time he said, stop an investigation, his power diminished. The power of the honest officers diminished. The power of the corrupt officers grew. So I got the evidence of the election frauds against the European leaders. It was, in fact, the extradition fraud. And so I used that to serve a corruption notice on the Crown and Parliament, and it revived use of the equity monarchy trusts and started a corruption remedy process that continues 15 years later. Now, the position that we have...
This is incredible. Wait 1 second. Are you saying this started 15 years ago and it took 15 years?
That's when the European elections were in 2005. In 2004, they were preparing the conditions for it. So in July of 2004, they had to stop the man who got the priming demand. He got a contract to service a fleet of vehicles for BP in Angola. He got acceptance by the Angolan authorities. I got him accepted by the London managers, the Angolan managers. So he had the contract with BP. He was in line to get 5 or 6 other contracts. We could have run 5 or 6 contracts. We only needed 5 or 6 contracts to get enough money for live and profitable usage of advanced electronic signatures for all of the other customers. There were about 100 different business activities where the small independent would be at no administrative disadvantage against the global corporate if he had advanced electronic signatures. Get one to provide the money to start the service, and there would be an explosion of businesses that could use it. So they took out the man who was able to deliver the priming demand. They thought I'd be too stupid to realize what was happening or too cowardly to do anything about it. Well, I was neither too stupid nor too cowardly. I got the corruption proof. I used it to serve the corruption notice on the Crown and Parliament, revived use of the equity monarchy trusts. And from that time on, Blair was doomed. He was either going to have to admit what he'd done, or he was going to have to complete the extradition frauds with the Queen and the Prince of Wales and the Lord Bishops observing everything that happened. So I've got one of these pop-ups again I have to get rid of. Thank you.
Well, this is rather earth-shattering. So you're saying that at this point you had him between a rock and a hard place. He had to make a choice.
Well, yes, and at every stage, he carried on with the fraud, and so the extradition fraud agreement needed the British authorities to commit innocence evidence concealment frauds before the Dutch authorities would complete the imprisonment fraud. So I forced the English judges into committing the innocence evidence concealment frauds. And that got corruption findings, unfitness findings, and dismissal priority findings against the judges. Prime Minister Mr. Blair could not service the dismissal decisions because he'd used law court judges for personal frauds. So it got an unfitness case against him, a remedy failure finding, unfitness finding, and dismissal priority finding. So he was told that either he signed a 10-month retirement notice or there would be a forced general election, a parliament session refusal, forced general election, mass publicity for the corruption proof, and remedy denial fraud proof. So under that pressure, he signed the 10-month retirement notice. So we got rid of him. He then spent the rest of his time in office making protection fraud arrangements that he thought would last his lifetime. You might remember that he was the peace ambassador to the Middle East.
I remember that. The irony of it.
Well, it isn't an irony. He had done, let's call it, bad business with everybody. Yes. So the European Union, the Russians, the Americans, and the British all gave him diplomatic status as the Middle East peace ambassador.
Envoy or ambassador.
It was part of the protection fraud arrangements. He did a load of things in England that were designed effectively organized crime defenses. And so the Crown and the Lord Bishops had to be very careful. They could not afford to take out a few corrupt officers, a few corrupt judges, knowing the system was designed to replace them.
I see.
So we had to run the process to shatter the relations within the protection fraud network. So Prime Minister Mr. Brown signed a corruption remedy agreement. He had absolutely no hope of performing the conditions because organised crime controlled the Labour governing majority. So it got a remedy failure finding, unfit finding, and dismissal priority finding against him and the Labour majority. You might remember that 10 years ago, we had the expense account scandals. Do you remember anything of that?
I'm not super familiar with that, living this side of the Atlantic.
Well, we had this expense account scandal, and it was managed so as to destroy the Labour governing majority. About 30%. Normally you'd have 15% of the members of Parliament not standing again. There was 30% that year, or for the general election of 2010. So the 2010 general election got office for the coalition government. And we had three honourable leaders. We had Mr. Cameron, Mr. Clegg, and Mr. Miliband. Mr. Cameron was Prime Minister. Mr. Clegg was Deputy Prime Minister. It was a coalition, so he was a leader from a different party. And then we had the opposition leader, Mr. Miliband. All three of them cooperated with the corruption remedy process. They did what the Crown and Lord Bishops needed them to do. So there was a corrupt investigation of the law courts for from May of 2010 until August of 2012. It got trial fraud proof, appeal fraud proof, and protection fraud proof against top judges. Well, judges all the way up the chain, but the trouble was at the top. And so the Lord Bishops made a remedy priority decision for the victims. And they didn't know who the victims were. So they authorised Parliament to negotiate with the top judges the exchange of immunity terms for remedy cooperation that included identifying all of the victims. The Protection Fraud Network rejected it, and they made a corruption continuity plan. It needed an intimidation fraud to silence Parliament, remedy sabotage frauds until the 2015 general election, and then whatever was needed to get a corrupt majority and immunity frauds. So the Protection Fraud Network used hung Parliament propaganda, trying to convince the voter that they should spread their votes around so that it was a hung Parliament. They failed. Prime Minister Mr. Cameron won a governing majority. So the Protection Fraud Network needed to get rid of him. And, sorry. Thank you. Someone's bringing me a drink of water.
Wonderful, wonderful.
Thank you. So what happened was they planned a ruin fraud against Prime Minister Mr. Cameron. It needed internet publicity by an innocent agent, censorship motive proof against the Prime Minister, a framing fraud against the innocent agent, and exposure of it timed to do maximum damage to the Prime Minister. Panama Papers Week prepared for a framing fraud exposure week, which did not happen. I found the case. The innocent agent cooperated. We got criminal conspiracy proof against the law court judges in time to stop framing fraud exposure week. So the ruin fraud needed top media managers and top politicians, very powerful people.
And they had them, right? Because, I mean, that's part of what this is all about, this crime syndicate or Protection Fraud Network. It has all the top people. It's got the media, and it's
it's not got. It hasn't got all the media. It has got enough of them.
Okay, so that's good to know that there's some out of it.
They've got so much money that they can buy
pretty much anyone or anything they like.
Yes, and they do. So there are honest people, there are honourable journalists, there are honourable politicians, there are honourable lawyers. The balance of power has shifted against them for the corrupt parties. And so what happened was Prime Minister Mr. Cameron could not do anything about the ruin fraud at the time because the Brexit referenda was the priority. He led the Remain campaign. he lost and then resigned. It was an honourable resignation. It was the right thing to do. Now, events have revealed that the ruin fraud conspirators included Home Secretary Mrs. May. She won the leadership contest and succeeded Mr. Cameron as Prime Minister. Her priority was protection frauds for the ruin fraud conspirators and the protection fraud network. So where one would have expected a Prime Minister who came into office, who realised the previous Prime Minister had been the victim of a ruin fraud that almost succeeded, it failed because an equity lawyer and a citizen cooperated in getting the criminal conspiracy proof against the judges. His governing majority did nothing to keep his name good. It was because we got the corruption proof. So you would expect any honourable Prime Minister who knew that is what had happened to the previous Prime Minister to make sure it couldn't happen to another one. Well, Mrs. May did absolutely nothing to deal with the ruin fraud conspiracy. She provided protection frauds for the people who'd committed it. So at the outset, we couldn't say that. I suspected it. I didn't write it anywhere. I just waited until I'd got the proof, and we've got it. So
how long has it taken you to get the proof?
Well, let's put it this way. We've had it for some time, but the remedy process, you see, once you complete one stage of the remedy process, you're into the next stage. And what has happened was the protection fraud network had the framing fraud appeal. We offered immunity to the police officer witnesses. They wanted an immunity deal. So the protection fraud network had to manage intimidation frauds to get repeat perjury out of the police officers at the framing fraud appeal. So it was the intimidation fraud that completed the criminal conspiracy proof set against the law court judges. And so the Crown and Lord Bishops used that criminal conspiracy proof set to decide the corruption remedy conditions for the 2017 Parliament session agreement. It needed an election-free period for a long session to manage the process that separated the ordinary officers from the corruption controllers so we could take them out. We didn't want to have any unnecessary casualties. So there were remedy cooperation tests of all justice agencies
and that's how you did it. I was going to ask whether you were in touch with the good officers or how exactly you did that.
Well, I ought to put it in order. When they decided they needed the long session, Mrs. May was given the choice of calling the surprise general election or facing a forced general election with mass publicity for the corruption proof. So she called the surprise general election, and she made no preparations for it. Part of the evidence for me was she had made no preparation, which meant the Crown did not trust her. Prime Minister Mr. Cameron, we trusted, so he would have known more. She did not know about this because they must have known she was a ruin fraud conspirator. So from general election day, for 6 months, there were remedy cooperation tests of the justice agencies. It got criminal conspiracy proof against corrupt officers and remedy unfitness proof against the law courts. We couldn't trust the law courts with case remedies. So we had to rely upon Parliament for mass remedies. So the process moved into the mass remedies stage. So we separated the ordinary officers from the corruption controllers. There were voluntary remedies. There was a week in which there was publicity for innocence evidence releases, no case admissions, prisoner releases, and public apologies. That was voluntary remedy publicity week. And then we continued to get...
Did that happen, though? Were there prisoner releases and all that? Wow.
Oh, yes, this was in February of 2018. So
I see.
We then continued to get complete the fraud proof against corruption controllers. On the 12th of June 2018, court frauds by appeal Lord Justices completed the proof set. It was used for judicial office unfitness cases against top judges in Parliament. The notice of the cases puts the case in Parliament and enables protection fraud investigations by the Crown, Lord Bishops and honourable members. So Mrs. May did nothing to process the corruption case against the judges. She did provide protection frauds for them. And what she did was she traded protection frauds for the judges for support for the Brexit deal.
Oh.
Now, she and the MPs who made the protection fraud deals needed total secrecy. They couldn't have emails or pieces of paper floating around, which said, I agree to do this corrupt thing, you help me to do another corrupt thing. It wouldn't, there'd be somebody who would blow the whistle.
Yes, you'd end up with the whole saga that we have over here with the emails on the server, Hillary Clinton's server, right?
Yes. So what has happened is Mrs. May had to have a signal she had got a deal majority. She went to South Africa and Nigeria and did a victory dance.
Oh, we all saw that.
Yes, that was the signal.
Oh no, that was the signal?
Yes, I know. Yeah. I mean, you have to laugh about it.
Yes.
But that was the signal she got the deal. So email notice of the protection fraud deals broke the confidence of some MPs to support the deal. Now, it may be that the MPs who didn't support it, who withdrew, some of them might not have made the protection fraud deals once they realised some people had made, or some MPs had made protection fraud deals. It made them much more wary. So there might have been some who did the protection fraud deals who withdrew, and there might have been some who had not made the protection fraud deals who withdrew. So she was then left with a poisonous situation. And we had this Brexit shambles because she was working for organised crime. Now, what it means is there has to be a forced general election, but we cannot, it has to be a fair election. So what we need to do is we need to have independent candidates in every constituency who are sufficiently credible that they can replace any discredited candidate of a major political party, because we cannot have loyal voters having to choose between unelectable candidates and unacceptable policies. So the care we have to take is great. The other thing that I had to be careful about was we could not have a forced general election giving a windfall majority to the opposition if the opposition had been involved in the frauds. Well, there is compelling evidence that the opposition leader has committed frauds. The citizens who service the equity monarchy trusts have protection rights from the Crown and Parliament, and protection enforcement by the Cabinet and Prime Minister, and enforcement accountability by the opposition leader. So the function of the citizen protection is it tests the Cabinet and Prime Minister and opposition leader. If the rot is at the top, it is the protection, Crown protection rights and Parliament protection rights. If they are not enforced, it means the Cabinet and Prime Minister are in breach of the protection obligation. And if the opposition leader does nothing to enforce accountability for protection, then the opposition leader is jointly responsible for the protection frauds.
And do you think also these the people, the rot at the top people, the organized crime syndicate that's in positions of power right now, are they going to be fully exposed? Is all of this going to come out?
Well, yes, because there have been desertions from the protection fraud network at every stage. There have been people saying, "Count me out." And so in order to carry on, the corruption controllers have had to be more and more flagrant in their frauds. Now, the judges demanded protection frauds, and so the Prime Minister had to do things to reassure them that she was still protecting them. One of the things she did was had the Attorney General issue a contempt claim fraud against the innocent agent in the ruin fraud case, and to put him in prison.
I see, yes, for contempt of court, yeah.
So, well, yes, but the whole thing is a fraud.
Right,
so
right.
There he is. He should be protected, and he's been threatened with imprisonment. You couldn't have more direct evidence against the Prime Minister and the Attorney General. Now, some of the cabinet ministers will say they didn't know anything. Well, it's unbelievable they knew nothing. Now, I can quite understand that when they did know things, they didn't know what to do.
Has any of this been reported in the British press? I mean, even over the years, starting from the time of Mr. Blair?
Yes. Well, if I use my fingers, right?
Yeah.
My fingers represent things that have been in the media.
Oh,
Nobody has yet said, this is how they fit together.
Oh, I see. So little bits and pieces have come out. Nobody's connected the dots and put it all together.
Yes. Well, to give you an idea how poisonous it must have been for anyone who's been able to live an ordinary life, it's been marvelous. They don't know how lucky they are.
Yes.
But there were two major problems the pharmaceutical industry had in 2000. In the 90s, they bought market frauds for drug treatment against non-drug treatment. So there were a whole range of things that happened, and they bought a massive fraud against the osteopath profession. They established a professional authority that was briefed to sabotage the profession. So in 2000, there were corruption complaints in more than 200 constituencies. That was almost a third of the constituencies in the United Kingdom. So there was a corruption debate. And it got an investigation commitment from the government. There was no investigation. Now, at about the same time, there was the baby organ scandal. I don't know, you look too young to remember anything about it.
I'm not that young, but on the other hand, thank you. But I'm not entirely certain which particular baby organ scandal you're talking about.
Well, what happened was that baby organs were used for drug research.
Okay.
And
I do know the story that Nilu Berry has, shared with the world. Yeah.
So what happened was that in the case of Nilu's niece, there was a decision to kill the baby to deliver on the organs, and it exposed the organ market.
Oh, I see.
Now, so the pharmaceutical industry needed parliamentary protection frauds for both the corruption investigation or corruption debate in the case of the osteopaths and the murdered baby case. So
the pharmaceutical industry was heavily involved in the organ trafficking?
Well, they needed it for research. So basically, somebody needed the organs. They thought the baby was going to die, sold the organs, and then when the baby lived, kill the baby. Now, so a journalist, because what I was trying to explain to you, things have been in the public domain. Journalists have covered things, but we have what's called question time of Parliament, of the Prime Minister in Parliament. And after question time, the camera showed the House of Commons with people milling around. And then there was a voiceover from a journalist who said, election campaign contributions are coming in unusually early. And that was all the journalist could say about Prime Minister Mr. Blair having sold protection frauds to the pharmaceutical industry. Now,
I see. They
might have thought it was all over, but Nilu Berry was a pharmacist, so she was able to interpret the hospital records as murder proof. Her father was an equity lawyer like me. So he was
a judge, right?
No, he was a lawyer, and organized crime was taking control of the Indian law courts in the 1960s. So the choice for him was to reject judicial office and offend organized crime when it was getting control of the courts, accept judicial office and stay honest and get killed, accept judicial office and go crooked, or flee the jurisdiction. He fled the jurisdiction. So I heard about him about 1967, and he was admired by my father and his friends. I just watched my father and his friends talking about this.
That's so interesting.
And then, so he did very well. He came over here and made a life for himself and his family. So when they met that challenge, they knew what to do. And that was get the evidence, force the evidence. Now, I don't know whether he understood how the equity monarchy trusts worked. But in any event, I needed a case in which a prime minister was involved with organised crime before it was worth the risk of giving a corruption notice to the Crown and Parliament that revived use of the equity monarchy trusts. So what I do know is that during the 45 years, the equity monarchy trusts were not serviced by the citizen. They fell into disuse. What it meant was the citizen just didn't do anything, so the others couldn't do anything. But the Crown continued to collect corruption evidence in case somebody served as big citizen to revive.
This is rather major. Are you suggesting that the Crown has been very aware of this corruption for a long time?
Yes, but the Crown was powerless until the citizen started doing something. I was told when they started the going for dictator powers that you couldn't, the equity monarchy trusts were there, but you couldn't take the risk of using them until you'd got a prime minister that you could take down. You had to maintain the confidence. There would have been loads of people in Parliament who knew what was right, but were scared of anything going wrong. So you had to have the extreme conditions, like the extradition fraud.
I see.
We had those conditions. I gave the notice. So the Crown and the Lord Bishops witnessed the completion of the extradition fraud, realized how far organized crime had penetrated the system. They have had to be very, very careful that they didn't act too soon. There had to be a remorseless and thorough process, and that's what we've got. So we now have a prime minister who's been providing protection frauds for organised crime, and we've got an opposition leader who has failed to call her into account for it.
Now, the very fact that you're speaking publicly about this right now makes me wonder if you've spoken about it publicly before, and if these parties know about it.
Well, they all know about it. But I spoke about it 2 nights ago, and I think that we had a recorded interview with Sean Maguire, and I think it was broadcast while we were having this this interview. Okay. So I did not use the internet. The organised crime had internet trolls. If I had tried to use the internet, it would have been so easy for them to do so much damage. I focused on getting evidence that was admissible by the Crown and the Lord Bishops. They use the corruption remedy proof standard. It is official records that are justice proof for honourable officers or guilt proof against corrupt officers and credibility irrelevance proof for the victim. So I make sure the documents contain everything that enables the Lord Bishops to make a finding. So they are able to compare the citizen document with what the official state document or court document evidence is.
And bringing this down to the basic understanding of people, minus the technical words, is you basically documented the cases of people who were treated unjustly by the court system, right? Who had their children taken away or their houses taken away,
yes,
and no justice being served. Right?
Yes, and I have not charged for my services. I couldn't have the best cases against the judges being neglected because of an argument over costs. So I just serviced the cases. They froze and stole my assets, trying to starve me out of servicing the remedy process.
Oh, I'm so sorry to hear this. Now, this is all part of what I think Nilu has also experienced, right? Nilu Berry has experienced with her house being taken away.
Yes.
And
yes.
Your office, I guess?
Well, yes. What they did was terminated my practicing certificate and then offered me another one with a corruption case prohibition in it. So effectively, the choice was, I had to choose whether I was an honourable man or a qualified lawyer. I decided I was an honourable man and I could cope with not being a qualified lawyer.
Oh, I see. And so they took away the license to practice, in a sense.
Yes. So what they then did, because of my stand, about 1 in 1,000 lawyers started investigating corruption cases. So they needed a disqualification fraud, an obvious disqualification fraud, for career blackmail of all of the lawyers. So they used my case, and in it they acknowledged that the citizen bundle contained corruption proof against the state prosecutor, and then made a citizen bundle exclusion order, evidence exclusion order, using an irrelevance reason. Well, corruption proof is never irrelevant. That judgment was used to blackmail many lawyers all over the country. There were lawyers saying, but we've got the proof, and they'd got corrupt officers saying, use it, and this is what will happen to you. So there were thousands of victims all over the country who were telling stories how they'd got an unlosable case and then it fizzled out and then the lawyers stole the evidence. It was how it worked. Now,
and the good lawyers who were trying to address this, did they get frozen out by the so-called example they were making out of you?
Some of them just lost the nerve to carry on.
Yeah.
And so the long and short of it is that where the judges thought they'd been so clever, they had given compelling evidence to the Crown and Lord Bishops that they could trust me. You see, it was all about confidence. I could start the remedy process.
Brilliant.
They had to be careful that they were dealing with someone they could trust to carry on. So we got the dismissal decision against Prime Minister Mr. Blair, and then the disqualification fraud against me. It meant that if there was a conflict between the court seal and my signature, there was a credibility presumption for my signature against the court seal. And I just kept going. And so there were
Fabulous.
loads of cases. And what's going to come out is effectively, I've revived the citizen identity. The dictators used to talk about the public interest that the state decided. And one of the signals that we were making progress with the remedy process was when journalists started talking about the citizen.
Very interesting. So do you feel that happened over the last few years?
Well, it most definitely did, because there suddenly came a time when journalists were they were talking about corruption. Corruption had been taboo when I served the corruption notice.
Interesting. And now actually more and more stories are coming out, right? I mean, they're sort of isolated perhaps, but little stories here and there of corruption.
Well, yes, but the long and short of it is, if you're going to remedy a problem, the first thing you've got to do is recognize it's there. And if my generation did not revive use of the equity monarchy trusts, I don't think the next generation had a hope.
No, because one, nobody knows anything about it, and two, we're talking about totalitarianism.
Yes.
Being run by the organized crime syndicate, right?
Yes. Well, what I did, I produced a document. I used to produce documents that, and I would get them stamped by the state and the law courts. And there was a document I produced acknowledging or disclosing that I was satisfied that Prime Minister Mr. Obama did not know anything about the ruin fraud conspiracy until after it failed. Because it was important that people in the United States, there were people over there who were very helpful, they needed to know that the ruin fraud conspiracy had done nothing to dent the relationship between Mr. Cameron and Mr. Obama. And then there came a time when Mr. Trump was being ridiculed because the polls were supposed to be against him. And a British politician was foolish enough to side with the polls. So I wrote a document that evidenced that I thought Mr. Trump could win. I didn't put it in those words. I wrote a confirmation that the work that President Obama had done had earned the opportunity for the American people to share in the development of advanced electronic signatures and the world lead, and asked him to make that available to both candidates. It was how I observed political neutrality between Mrs. Clinton and Mr. Trump, but countered the opinion of a British politician that the polls said that Mr. Trump's chances were doomed. So here we are all this time later, and Mr. Trump has been most helpful. We had the Paradise Papers because he cooperated. He trashed most of what Mr. Obama did, but he did not trash Mr. Obama's contribution to the corruption remedy process. He carried on with it. And one day, people are going to know all about it.
Yes, it certainly sounds really like something like a major detective story over here that's going to be coming out shortly, right? I mean, thanks to your efforts. And
A
Your
lot of
efforts,
people.
it sounds like. You,
Well,
there are a lot of people behind you.
there are a lot of people who've cooperated one way or
Okay.
another. There are people who have given me evidence and remained anonymous.
Okay.
In some
Okay.
cases, I've been pretty certain who they were, but I've not
Very
pursued.
interesting. So you needed that kind of help, it sounds like. You needed certain doors to open.
Well, it's all confidence, isn't it? There are a lot of honourable people who find themselves trapped because corrupt officers have control. It's
Right.
about shifting the balance of power for the honourable officers against the corrupt officers at every level. So we are, we have the candidate, the council candidate who's doing the election research, promoting the idea of abandoning dictator governance with the European Constitution and reviving equity governance using the common law and the equity monarchy trusts. Now, he has no real experience, but he's using his campaign to test how the media and voters respond to that message. And if we get things right, there will be that policy that can be adopted by many independents. All the political parties provide the think tanks and the policies and all sorts of work, and you get the candidates as the salesman who just promote them. The independent's got to do his own thinking. So what we're doing is giving the independents a package that they can, that is different from what the establishment politicians are giving. And that means that if the established candidates for the major parties are discredited during as a result of the forced general election, we will be able, hopefully, to replace the discredited candidates with substitute candidates so that the loyal voters are not left with the choice between an unelectable candidate and unacceptable policies. That's
Brilliant.
why we've had to be so careful.
Yeah, so that in a sense sort of wraps up in a nutshell where you are currently. You've managed to push through with this entire process, and you're now at the point where you're talking about a forced general election, and I'm still not clear as to whether is there actual time for this election? Is it
Well,
in terms of cycles, has the time
well,
come around for an election, or are you going to be demanding one?
no. You see, there's no point demanding an election unless you're ready for
Okay,
it.
yeah. Unless you have
Sec-
the candidates. So you're talking about building up platforms and building up candidates and finding the
well,
candidates?
well, I can't go round recruiting every candidate. What I can do is, you see, I've made the argument that the major political parties, the selection committees, they do not know whether or not they're going to be faced with a disgraced candidate. It's for them to ensure there is someone independent in their constituency, an independent candidate who they can adopt in the course of the campaign. Now, so effectively, I'm making the argument that's what should happen. And by developing the policies for, let's call it, the citizen candidates, I'm demonstrating that the political parties have absolutely no excuse for failing to make these safeguard arrangements so their loyal voters will have someone they can vote for. And there might be some people who've laughed at me. Eventually they stop laughing. As the process goes on, they realize that I've got it right. And if they just do nothing, they run the risk of independents taking all of the seats just because they have sabotaged themselves. And the other thing that is worth mentioning is that I write material and sometimes the journalists pick up on part of it. They never just put it all in context. One of the things I was saying was we need a caretaker prime minister. You need a replacement prime minister if there's been a political failure. You need a caretaker prime minister if there's been a corruption scandal that requires the establishment to reorganize itself. So the journalists one Sunday morning about a fortnight ago were talking about the idea of a caretaker prime minister without any mention of the corruption scandal. You see, the Brexit negotiations on their own were a political failure. They were a corruption scandal because of the protection fraud deals. Now, they, by using the phrase caretaker prime minister, they were implying acknowledgement of the corruption scandal without actually saying there was one. You see, I said about how these different things have been in the public domain. How many people on the Sunday morning listening to the journalists going on about a caretaker prime minister would have appreciated that subtlety? The journalists will be able to come out later and show footage that people might recognize of them going on about a caretaker prime minister. But they won't be showing, oh, we kept quiet about why one would be necessary. So we might even reach the stage where there is a short session of Parliament with a caretaker prime minister to enable the parties to organise themselves, because the prime minister and the opposition leader have both been involved in the protection frauds.
Wow, that's really interesting. So in a sense, that would open the door for other truly credible and reliable and honest and citizen-oriented style candidates to come forward, whether they're in the political parties or they're independents, is what you're saying.
Yes, effectively, let's just give them enough support that they can confidently present with something to offer.
Brilliant. And you are talking about having a package to give people as well.
Well, that's what the research is about.
Okay.
You see, the research might not go very well. I mean, this black man who's arguing that race law has done nothing for him. He's better off with the justice priority obligation and the common law than he is with all of this racial favoritism that's supposed to be for him. And but he's been through a grueling time. What happens when these things come to an end? People they live on their adrenaline for a while, and then they collapse. Well, he might carry on, and the adrenaline might flow because of the election campaign, or he might just get burnt out because nobody would choose to be competing in those circumstances. But at least he knows he's appreciated, and he has the enormous satisfaction of having walked out of the Crown Court with compelling corruption proof against the judges. And anyway.
Mm-hmm. Well, this has been an extraordinary conversation, Edward. You've covered so much of it, and you've gone so much into the history, and you've been relaying very exciting things about that are happening right at the current level as well, the current day level. I have one remaining question about those corruption cases, the fraud evidence that you have collected. How will those people get justice? How will their cases come to fruition?
Well, there are a variety of ways in which you can do the justice. There are some cases in which no justice can be done at all. The children that have been stolen have lost childhood with their parents. They're not going to get the childhood back again. And enough people have children who become independent and then have very little to do with them in adulthood.
Yes.
It is.
So you mean those children have aged out of the fostering system even? They've grown older?
Well, yes, but not only that. It is, if you take a poor child, put it in care and give it a load of money, how on earth can it then adjust back to the poverty lifestyle of the parents?
Yes.
I mean, it is. You can't do justice altogether, but because you cannot remedy all wrongs does not mean you should fail to make an effort to remedy what you can. The first remedy is you take out the people who manage the corruption, and you do your best thereafter to ensure as much justice is done as possible. So you stop things going wrong, you try and put things right. And in some cases, money will do it. It will never do it completely. In some cases, it is the restitution of stolen land.
So it's restitution for damages or compensation for damages ultimately is all that can be done. But that's a brilliant statement to make, actually. In all cases, remedy can't be achieved, but that doesn't mean the effort to achieve remedy should not be taken. And that's the spirit in which you have acted, certainly, right? And everybody who has worked with you to try to gain justice for these cases.
Yes.
Yeah. Brilliant. So Edward, I would like to thank you so much for the work that you have done, the tremendous work that you have done, which sounds absolutely earth-shattering and will, it sounds like, begin to make massive changes in your country, and I hope in mine as well, and in Europe as well, somehow. I can't imagine how, but somehow. And, thank you for coming forward today. And just to say, what would you like to leave listeners with? What would you like to ask people to do to help or assist in this process?
Well, we have two challenges. One is how we persuade independents to accept the responsibility of standing as independent candidates. The second is how do we manage the introduction of corruption control jurisdictions in the republics. Now, I suggested to Sean Maguire at the interview 2 days ago, I said, well, I can't remember exactly what I said, but I know what I meant, was Ireland is a republic, Ireland shares so much with the United Kingdom that we're effectively one people split with the jurisdictions. So the equity monarchy trusts are what we've had to control corruption in the United Kingdom. They have enormous problems in Ireland. And so the challenge is, how do we get corruption control jurisdictions for the citizen against the state in a republic? Now, the other thing is, I think that when most of the British people understand what's happened, this corruption control process could be a wholly British thing. I thought by inviting the Irish at the outset, they would share the growth of the thing, and they'd realize it was for them as well as everyone else. And so if the Irish face the challenge of a corruption control jurisdiction in a republic, and it works, it can work everywhere else.
That's brilliant. Okay, so that was your intention when you brought the Irish in, and what they're doing is very similar to what you were doing in the UK.
Yes, but there is a connection. Sorry, these pop-up things come on the screen, so I have to get rid of them. So the man who was a political prisoner had an Irish surname. He was half Irish, half Dutch, and all British. Right? So,
of course.
And so when the French and Dutch rejected the European Constitution, the political leaders were left with political prisoners held for a cause the people had rejected. They decided to carry on and get referenda in error. They expected it to accept the jurisdiction of the European Constitution. They rejected it in 2008, and so they were made to vote again in 2009. From throughout the period they planned the Irish referendum, they were holding a political prisoner who by descent was half Irish and had an Irish name. And so it is definitely an Irish, he's got Irish relatives.
There's an Irish connection here, is what you're saying. Yes.
Yes.
Mm-hmm. So it's sort of inbuilt.
Yes.
So that's brilliant. That's brilliant. So, but that's really reassuring as well to hear that process that you have undertaken over here in the UK can then be applied elsewhere in similar fashion.
It has to be. They spent the 45 years developing dictator powers. Then in America, after 9/11, the Americans started taking dictator powers that were very comparable. Now, we have to unravel the mindset that says trouble, therefore more power for the state. And we unravel that, we awaken the citizen to manage citizen responsibilities.
Absolutely. Yes, just a minor task like that. So, but we're on the right track over here. Speaking out about it is the first step. And I'm delighted and honored that you chose my show to speak so extensively on the subject and share all of this information with the world. So I hope you'll come back and continue speaking about this and continue guiding people possibly toward how the ordinary citizen can, step forward and take action in this space.
If any of them have got any bright ideas, I'm most interested to hear.
Brilliant. So can we publish your email address to people, or how can people best reach you? What would be the best?
Well, yes, you can give them my email address if you like.
Brilliant. Okay, so I'll put it below the video, and I'll offer up any description that you would like to share, such as, for instance, the write-up you gave me. If you wish, I can put it up.
Yes, if you like. Well,
be happy to put
let's be. I've sent you a few sample documents, which you might not have had time to read.
I haven't had time today to look at them, but I will.
But there is so much. I mean, it is.
I have looked at some of the documents you had sent earlier, so I'd sort of been keeping tabs on what you were doing for a little while.
Oh, I see. Okay. Well,
yes.
I don't know what's the right way to do this. I'm not a broadcaster or a journalist. It's how I've got all of the evidence that enables the major decisions. Okay. How we move the people into picking up the responsibility. That is a different challenge. I wouldn't pretend that I've got anywhere near the talent to get a following such as you have, but what I can do is say now is the time for us to be focusing on the very positive message that we are getting things right and getting independent candidates and ideas about the actual campaigns they can run. A very interesting thing, as I said, this black man who's saying that the race relations law has not served him well because it denied him the justice priority obligation or rights. But he also was complaining about gender education in schools. And I said, well, it's an identity confusion fraud against all of those children who don't need it. Now, once I gave him the phrase identity confusion fraud, he responded very positively to that. Now, there will be people who know there are issues. I can't apply my mind to all of the issues. What we could do is identify what the issues are and find a phrase that people can take in order to deal with the issue.
But it's not just a phrase, is it? It's the whole process that phrase represents.
Well, yes, but when you say that you have the whole process, most people can't fight the process. But
right.
Give them a phrase.
That's
identity,
a brilliant
confusion,
notion, exactly.
Fraud. Now,
right.
How many different issues? If the issues are raised, if we find some efficient phrasing that deals with it, more people will feel empowered that they can resist what they object to.
That's brilliant. You know what it strikes me, Edward, is that you kind of need a continuing presence in the media, possibly. You need you need to be on a lot of talk shows. You need to put all of your ideas out there, all of your information out there, so that the hope that your process represents is known to everyone. And so they can begin to apply their issues to your, to the language that you're talking about, the phrasing that
Yes.
you're talking about, and the process. Because basically it's a challenge to the corrupt system,
Yes.
pointing out that this is fraud. Rather than saying, this is injustice and you can't do that, you're just pointing out that it's corruption, fraud.
Yes. Yes. In fact, my father said, you only ever have one right, and it is to decisions that are reasonable by the objective standard. Absolutely everything else can be lost because of a change of circumstances. And
That's brilliant.
so it means that if we apply that thinking to all of the issues that people don't like about dictator governance, you see, what the dictator does is takes a minority, pretends to be protecting the minority in order to oppress the majority.
Absolutely.
To have race relations law, but a black man is not allowed to make a racial complaint. And the very fact he wants to make one means he gets arrested for racism.
That's
it
huge.
Volumes.
Absolutely. And then, the current situation, the whole surveillance state and the surveillance state abuses, this whole notion, this is the invention of fears as well, right? And the creation of false flags and so forth, which is also corruption and fraud ultimately, right?
Yes. And data protection
is
dictator protection. The proof is when the citizen needs evidence out of the state, in corruption cases, they can't get it.
You can never get it. You can never get the video surveillance. You can never get the cyber hacking surveillance, etc.
So we can find some phrases that that ridicule the authorities for their data protection law. Maybe your audience can apply their mind to that. I don't mind having a look at it. I still have to produce documents in cases.
I see.
The work
it has to be done case by case, and documentation has to be produced for each single case, is what you were saying.
Yes, and there's no precedent. Some of the documents you might have read might seem repetitive. That is because the Lord Bishops need to be able to make a finding, a notice finding. The judge or the policeman or whoever knew the X facts. Well, you have to write down X facts in order for the judges to say due notice finding. And
so they need some kind of comprehensible template, in a sense, that will guide their thinking through these cases.
Well, I try to give them familiar
terms and modalities.
Well, yes, things that have already been found to be true. I use them again so they can be used, the truth can be used for different cases. And because I thought it would save them having to try too many issues. I mean, so anyway, look, I'm more than grateful for the time you've given me. And let's see if we can do something.
Yes, absolutely. And we'll pick it up again next time. So I'll just say thanks, everyone, for watching. Thank you again, Edward. And we'll talk about this all again very soon. Thank you and bye-bye. Have a good night, everybody. Bye-bye.
Bye.